So you'd have to be under a rock not to be familiar with the fact that the new Act came into force on the 4th of April, and we've got Diane here today because in preparing our legislation, our drafts people, our Parliament looked at the Australian experience amongst others, and were obviously impressed with how their relatively new regime was working. So we've got the advantage of just across the ditch having a lot of people who are familiar with how the Australian courts and the Australian regulatory bodies have operated, and we're expecting that our WorkSafe will follow suit. Of course, New Zealanders don't always do it the way the Australians do, so there are no guarantees, but it's going to be a good set of guidance that we get out of our Australian colleagues. There's a lot of management speak around the Act, but there are two concepts that I think do encapsulate the new philosophy. The most important being the top-down, I think. The Act is quite deliberate about making those at the very top of the chain, and that includes directors, very deliberately includes directors, requiring them to satisfy themselves by complying with their due diligence obligation that there are good practices in place and that if there are problems, they're being addressed proactively. And if they fail in any of those obligations, they face some pretty serious sanctions. So that's new. We've had a lot of seminars that we've had to deliver to boards because board members are very anxious about what this means for them. And that top-down approach, that applies to anybody, not just boards, anybody who has the capacity to influence the management of the business. So that could be your health and safety director, almost certainly, your HR manager, your CEO, almost certainly, general managers. Anybody who has significant managerial capacity to influence could be deemed to be an officer and therefore could face those really heavy sanctions if they turn a blind eye to or aren't deliberate about ensuring compliance with the new regime. Here's the dry stuff. As I say, Diane's got all the sexy stuff. She can talk about what she's experienced in workplaces, but you do need to know some of the key legal definitions. PCBU is the new catchphrase, person conducting a business or undertaking, so it's not just focused on companies and employers. They've used this broader definition to capture all sorts of working scenarios. I've talked to you about officers. They're the people who are either board members or who exercise significant influence over the management of the business, and I think that could go really broad. And then we've got your worker. Your worker could be your employee, your contractor, your subcontractor, your hire company employee assigned to work, and your volunteers, if you're lucky enough to have volunteers in your business. There can be an overlap of PCBUs, so the scenario we're dealing with today is obviously in the context of recruitment. So we have a contractor assigned to an IT-related role in a client organisation. The scenario I've put down here, and I think I've stolen this from Diane from a call earlier in the week, but she'll give you lots more, I'm sure. The contractor works excessive hours in order to perhaps deliver on the project out of commitment, or there's a success fee, or they're just very diligent contractor. They have a fatigue-related accident causing death. WorkSafe comes in to investigate. The parties that could be the subject of prosecution in that are at least the following. So that's the contractor, him or herself, because he or she may be trading through a company that they've constructed. So they've created a business. Andrew Shernack Limited provides services as X, and that in itself could legitimately be treated by WorkSafe as a PCBU, with the responsibility to ensure that Andrew Shernack in person is kept safe in his role. The client organisation, so the end user, who's receiving the services, they've seen Andrew coming in looking stressed, tired, and then the agency who has placed me with the organisation, has it ensured that what I'm doing is being done in a safe way? Has it communicated with the end user to ensure that there are safe practices in place? So I hope that gives you a taste of why the new regime is not just limited to your heavy industries. And at that point, I will hand over to Diane with all the war stories.
So my name is Diane Joubert. I'm a Well, I like to think of myself as a management consultant. I have been for a long time, but more recently I'm an auditor. So I set up Certex International about 10 years ago. We're an accredited body that does certification audits in quality, safety and environmental management. So if you've heard of ISO 9001, yeah, that sort of stuff, that's what we do. But we also do a whole lot of work in the recruitment industry. So we've worked with the RCSA, we've worked with ICRA, and we do a lot of work with recruitment agencies. That's across your recruitment best practice requirements, but it's also on safety. And how do you manage that safety? And it is a bit tricky when you're looking at all these different PCBUs, as Andrew has explained. All of these different parties share responsibility. It's not a requirement that you wrap your employees or workers up in cotton wool. It's just whatever is reasonably practicable. Safety is everybody's responsibilities. It's not just where you work, it's yourself as well. Managing health and safety risks, what we're looking at here is there are 4 main steps, and for those of you who already have safety in the workplace, you'll be familiar with this, so I won't belabor the point here. It's about identifying the hazards in your workplace. It's assessing these risks to work out which are more serious than others and what can be controlled, and controlling those risks, and then reviewing to make sure that it's working, because there's no point putting in place something which you think is the bee's knees if it really isn't effective, if people aren't taking notice of it. The responsibilities are joint, overlapping, and you can't contract out of it. So you can't try putting into the contract that you're only going to be responsible for this much and for the host organisation that much or the other way around. That won't work. So the responsibilities of the host client are, and the first 3 things are pretty general, you'd be doing them anyway. So maintain an effective safety management system and a safe work environment for all of your workers, regardless of whether they're in permanent, short-term, long-term, whatever. Ensure all workers are aware of the safety requirements and are competent to undertake their roles, so don't get them doing things that they shouldn't be doing. There was a case back a couple of years ago now, but a tragic case. There was a fatality. A young fellow had been placed, and this is a blue-collar example, he'd been placed to do some manual labour work on a client site. But while he was there, he'd said to the host client, "Really keen to get my forklift driver's licence, need a bit of practice, do you mind?" Yeah, not a good outcome. But the host client said, "Yeah, sure." So this guy drove the forklift truck around. When the accident occurred, it toppled on him. When that happened, the lift had been extended to its fullest extent and he was doing a sharp turn and way too quickly. It transpired he didn't have the licence, he shouldn't have been doing the work. So not only did the host client cop a fine for their part in that, but also the on-hire firm, because they should have made absolutely clear to this worker that that's not on. You don't go doing those sorts of things. You're not qualified, you're not competent. So maintaining the competency of all your workers to make sure they can undertake their roles safely is very important. And to respond appropriately in the event of incident. So the worker's on your site. If they are injured, it's up to you to deal with that. Get medical attention immediately. So those 3 things are common. Then, in particular when you're dealing with on hire, it's really important to specify the activities and the responsibilities that this worker is going to undertake. Because otherwise, how would the on hire firm know what skills to provide you? It's usually not done very well. We'll have a look at that in a bit more information in a few more slides. Don't change their role without approval because, well, for the same sort of reason, and also inform the on-hire firm of any incidents. So in a nutshell, they're your responsibilities, and the responsibilities, just so you know, of the on-hire firm lies across these 3 areas. Firstly, with respect to the host client, yourselves, the on-hire firm should be asking questions about the safety requirements and the safety management system that you have in place. So again, in a few more slides, we'll look at some of the questions that they might be putting to you, but you can expect the on-hire firm to ask you about how does it work, what are the hazards and risks on your site, how well are they being managed. Then they need to look more carefully at the particulars of the job that the person is being asked to do. So will they be driving a forklift truck? Are they there as an IT consultant, but will they really be shifting equipment around and plugging it in and unplugging, things like that? And what skills will the worker need? That could be their skills and experience, it could be the licenses, it could be what personal protective equipment they may need. So there is shared responsibility across both, but the areas in which you will need to really focus are a little bit different. So your on-hire firm will be looking at these three areas. The first step is you as the host must provide a clear and comprehensive job specification. You give that to the on-hire firm so that and then the on-hire firm should confirm the host site is safe. Then they select the worker, they provide general safety training and information on the host site and they give that to the worker. So that's very general information about their general safety responsibilities, the general rules and guidelines around what they should be doing on site, what do they do if there's an incident. So it's very general information. Then the host, once the worker comes on site at your sites, the host is to provide specific training. Where's the exits, where's the fire extinguishers, when they have an injury, who do they go and talk to? And then finally, the host and the on-hire firm must maintain communications throughout the engagement. This information here comes from a standard that Certex has developed over, it was released last year. And it goes into detail about the job outline, including things like the principal duties and responsibilities, the competencies, the licenses, memberships, those sorts of things. So some of those are going to be relevant in the workers that come to work in your place, in particular perhaps licenses and memberships. It also looks at the expectations of the host. So what are the other things that the worker needs to be aware of if they're going to come and work for you? I worked in one place came in as a consultant, in fact, and it was my practice to walk in and say to everybody, "Good morning, how are you? Good morning, how are you?" And after the second day, the managing director pulled me aside and said, "We don't talk to anybody, they're here to work, so don't come in and say anything." It's okay, it was their business, their job, but they could make the rules, but you need to let the recruitment firm know those sorts of things. And then the other part is the selection criteria. So what is it about the worker that you need to know is met? What are the criteria for skills, training, registrations, etc.? Often in the industry, it's very hard to get these things right because you come to recruiters because these things you don't know and you're looking for their assistance. I get that. However, when it comes to safety, together you have to work out exactly what you're expecting the worker to do and what the requirements for the work are. The second thing is, how does the on-hire firm go about assessing the safety of the host site? This can be really difficult because sometimes you haven't been to the host site, sometimes it's an awfully long distance away, travel time to get there is very tough. And also, for safety and security reasons, sometimes it's not really the right thing for someone to wander through with a little checkboard and tell people that your safety's not up to scratch here. You might say, well, who are you to make that call? So there are a whole lot of problems with this, but it is important that it be done. The recruiter does need to know that it's a safe site. And what has been developing in Australia is a two-stage approach. Firstly, it's a preliminary check. Just be aware of the kind of industry. Is it mining? Is it agriculture? Both of them very high risk. So immediately you would be aware that there's got to be some more assessment and care taken. You might ask what their safety record is. If the reason you're filling the role is because the previous incumbent got killed, well, you'd kind of want to know that and then have a look more carefully at how they assess and manage safety. If they've got certification in one of the management standards, 4801 is just Australia and New Zealand, but that's the safety certification. But there are lots of other ways that you could assess the safety of the site. 4801 can help, but it's still not the end game. You can ask for the workers' experience, those who have been there. How have you found it? And I'm sure they would tell you. So there's some high-level preliminary checks you can do. Once you've decided that it's worth going further, then you'll probably need to go on site and see for yourselves. Now, as I said, oftentimes it's not the best to work with one of your own people because they may not be trained, they're there for sales. It might be a good relationship building opportunity though, so there is some good benefit in getting the recruiters out there. But we use, I do a lot of work with ICRA. It's an iSafe program where people like me who have safety qualifications go out and do the assessment. The benefit for you as the host client is that it's one visit by one qualified person, so it's far less disruptive than having lots of people coming in and doing the same thing. And that one report is shared with everybody else who's in the program. So, so there have been a few tools and services that have been developed to help with this. Okay, so here are some of the common risks in the office. Sedentary work, people working for too long, sitting in their chair, getting that bad back. Bullying and harassment, that's a really big issue, could be a really big issue, and a large part of it is not understanding what comprises bullying and harassment. Even today, years ago when I was working with a consulting firm, one of the young consultants was being sexually harassed by one of the clients that she was working in. And she was very young and we hadn't really heard about it. This was about 20 years ago. But I'll never forget the impact that it had on her. She mentioned it to the managers in the office and they had no idea what she was talking about. They did nothing. And this poor woman went from being outgoing, vivacious, to wearing no makeup, wearing drab clothes and just shutting down. She closed in on herself. It was a terrible thing to see. So the impact of this bullying can be really profound, and it's important people understand what constitutes that. In Australia, there was a case that came up just recently of a poor young apprentice who'd been bullied over many years, and it was atrocious what was done to him. And in the court case, he said, I didn't mind being spat on in the face, or if I had an option between the emotional abuse and then the physical abuse, he said, you can spit in my face anytime, you can pour paint on me, you can, put things in my shoes, all of these things and worse were done to him. But he said it's the emotional abuse, which I really don't want to go back there and do it again. Threats, ergonomics, it's a clear one. Threats of violence, including bomb threats and armed offenders. Again, in Australia, and I guess many of my examples come from Australia, later last year there was some online threats, bomb threats for a lot of the schools. So most education facilities should now have some element of managing bomb threats or violence against their staff and their students in their procedures. Slips, trips and falls, reaching, manual handling, working in remote or other locations. For those of you who do put your workers into other locations, you do need to be aware of how are they going to get there. Are they, do they have a valid driver's license? Have they had drunk driving convictions in the past? So you have to think a little bit more broadly. And worker health issues. So you need to understand for your own staff, what are they diabetic? Are there any other special awareness that you need to maintain their health when they're on your site? And the last slide is just to take you through this 4-step rule, which is something that I've developed over a period of time. Firstly, what we want to do is make sure people aren't injured, but secondly, if something terrible does happen and there's an investigation and you're standing in front of the magistrate in the court, these 4 steps will help. Hopefully they're in place. So if you can demonstrate that you do know your legal obligations, so you understand what you're responsible for, you should then design your policies and procedures that reflect not only your legal obligations, but also the workplace. So they've got to be consistent with the work that you're doing. You've got to implement these within your business practices. And then finally, you need to keep records. If you can demonstrate all 4 things, then people can't ask anything more of you. You'd probably just about meet 4801 certification requirements as well. It's all about making sure that you identify the risks and deal with them, but can demonstrate it. All right. Thank you. I'll sit down again and hand you back to Andrew.
Now, this is a real change of pace. It's an issue that RWA has asked me to talk to you about very briefly before you're on your way. I don't know if any of you noticed in the news this week, there was a story about the Auckland Museum recruiting for a new CEO, I think it is, and it's a global recruitment process. And the museum's engaged a recruiter in the UK. And that UK recruiter has asked a number of questions of candidates, one of which was, what is their sexual orientation? Now that received a bit of coverage in the Herald, sort of page 3, and a local employment lawyer said that's outrageous. You know, clearly that has no bearing upon the ability of the person to do the job. So there's a reporting obligation, and that's why the question was asked. It was a perfectly lawful question to ask in the UK. Completely different regime here. So RWA, and it is relevant to what I'm talking about now, RWA has asked me to talk to you about what you can ask of candidates and when you ask those questions, particularly in the context of health information, but it applies to any protected ground of discrimination. So religion and political affiliation and sexual orientation are also protected grounds, but disability is a protected ground of discrimination too. So what can you ask about a candidate's health? And there are really two key legal issues. Privacy Act says you can collect personal information from employees about their health potentially if it's for a lawful purpose. So you can't go on a nosy, I want to know your medical history, where that has no bearing on your role, but if you need to be satisfied that they have certain motor skills in order to perform a function, then you've got a lawful purpose for collecting information about their ability to function, to perform and be able-bodied, if you like. And you must use that information only for the purpose for which it was collected. So you can only ask questions where you've got a legitimate reason. You can't just go on a fishing expedition because you like to know people's backstories. The next level down is to then, when you have a tangible role that you're considering appointing them to, you consider their skills and qualifications and you determine whether they're the best candidate, or on the shortlist at least. If you get to that shortlisting phase, at that point I think you're entitled to drill down a bit deeper. You can say, well look, here's the job description and here are the dynamics of the workplace, and it is a demanding professional services environment with after hours work and an expectation of availability on devices after hours, and we're dealing with a lot of US clients, so the time zone means it could eat into your personal time. At that level, when they're actually on the cusp of or near to being appointed to the role, you can present that information to them and repeat the question and say, having regard to those factors, are you aware or do you need to disclose to us any medical conditions that may impact on your ability to perform that role? I think at that very high level, when you're just doing your first cut, drilling down into people's mental health history would be seen as too invasive. So I think it's a two-stage process: threshold question, and then give them the job description and give them some insight into what the role is in a bit more detail in order that they know all the dynamics, and then ask the more detailed question.